Hello, I'm Eric Matisik, co-chair of Denver Startup Week. Last year, we were able to bring the global audience together for Denver Startup Week, and this year, we're excited to welcome that global audience back as we celebrate and showcase the best of entrepreneurship that the Denver ecosystem in Colorado has to offer, in Denver and beyond. There are lots to explore this week, but most importantly, we're excited that you're joining us. We have nearly 50 sponsor companies who contribute to make Denver Startup Week possible. Let's show our love for these companies today and all week long. Thanks to our headquarters and title sponsor, Amazon, and our title sponsors whose leadership makes this week come to life, Capital One Cafe, the Downtown Denver Partnership, Fluid Truck, Hotel Engine, and WeWork, and our track sponsors who've made all the great content you're hearing today possible, which includes our founder track sponsor, Kickstart, our growth track sponsor, Friday Health Plans, developer track sponsor, Quizlet, product track sponsor, Palantir, design track sponsor, Battery 621 and the Public Works, people track sponsor, Exactly, and the spotlight event sponsor, Strat Labs. Our headline event sponsors are bringing this excitement to the entire week. Thank you to B-Side Fund, Colorado Public Radio, Comcast, Coors Brewing Company, Denver Pavilions, Entrepreneurship at the University of Denver, Gusto, JP Morgan Chase, Method, Moss Adams, Pi Insurance, Promontory Mortgage Path, Red Bull Basement, Southwest, Tattered Cover, and the VF Venture Foundry. Finally, thank you to our sponsors and member sponsors who are listed on the screen, and thank you for your support of Denver Startup Week. Now, let's get to it. Yeah.
Hey boss, Mountain West Q2 forecast 2.3 million.
Nice. Are you kidding me? Come on.
Ugh, another one.
Hello everyone, welcome to Denver Startup Week. I'm Ashley.
And I'm Emma. We are the People Track co-chairs and members of the Denver Startup Week Organizing Committee.
Thank you for joining us for the 10th anniversary of Denver Startup Week. At Denver Startup Week, we strive to make all of our sessions a space where attendees can connect, learn, and grow, regardless of age, gender identity, gender expression, race, ability, or sexual orientation.
A special thank you to our sponsors for their support in helping us to keep Denver Startup Week free and accessible for all, especially our People Track sponsor,
Hello
Exactly.
everyone, welcome to Denver
On
Startup
that
Week.
note,
I'm
please enjoy the
Ashley.
session
And
and the
Emma.
entire
We
Denver
are the
Startup
People
Week.
Track co-chairs and members of the Denver Startup Week Organizing.
All right, over to you, Bill.
All right, and I wanted to activate my screen sharing so that I could show the slides. And it's disabled, so I need someone to enable that, the host.
All right, try
All
now.
right, perfect. Here we go. All right, you should see a screen that says top tips and to-dos. Perfect. Well, Should I launch right in? Are we any more intro?
Launch right in.
All right. Good afternoon, everyone. Thank you for attending. We're going to talk about top tips and to-dos, employment law for startups. My name is Bill Berger, B-E-R-G-E-R, and I'm an attorney. I do labor, which is union-related matters, and employment law, which is pretty much everything else, wage hour, EEO kind of things, policies, handbooks. I'll explain a little bit about my firm here in a minute. But today I want to talk about top tips to help you avoid employment risks for your startup. And the word top, when an attorney uses a metric like that, we're actually supposed to, as part of our ethical obligation, identify what that means. So let me identify what it means. It's just my own sense of what I think is a short list of possible risks based on my own 30 plus years of practicing law that I think should be, the things that for startups to start thinking about. It's not an all-encompassing list. There are plenty of other risks. And I think this certainly isn't legal advice. It's not custom to any company, and any company's own business practices, size, location, footprint, all those kinds of issues will define its own exposure. These are just kind of the top issues that I would say, would be my short list. That's about all it's worth in terms of the word top. All right. What are we going to talk about? We're going to talk about a handful of things. Independent contractors, overtime pay, meals and rest periods, vacation, paid time off and sick leave, various miscellaneous things, taxes, workers' comp, unemployment, new hire reporting, and then record keeping. If you have questions during the presentation, please feel free to use the chat function or the Q&A, and I will be trying to monitor that as we go along, and I'll take some pauses as we go through to review those questions as well. The slides are available upon request. You can email me at that email address, bberger, B-B-E-R-G-E-R @L2SLegal.com. And the webinar is being recorded, as I understand it, and I think it's going to be available on demand following the presentation. I had down that I would email and post the details to you, but I actually don't think I will now that I kind of understand how it's going. I think that the Startup Week administrators are going to be letting you know how to do that. So I'm not sure how to do that, but you can reach out to them with any questions about that. If you do want just slides, feel free to email me and I will email you the slides. Sources for information, my Twitter stream is right here. I'm Bill C. Berger on Twitter, and on L2S Legal, I do keep a blog, and it's free, and you can sign up and get detail on legal developments as they come out. A couple of quick disclaimers that should give here in any kind of a legal presentation like this. Number one, this is not legal advice, so I cannot give legal advice to someone that's not my client. This isn't legal advice. This is just general information, and general information does not substitute for legal advice. You should contact your attorney to obtain legal advice with respect to any particular legal matter, to understand how any law might apply in your particular situation or your company's circumstances. This is just information that is general education. All right, a couple of breaking news items. You've seen, and last Friday, I believe it was, additional guidance came out regarding President Biden's vaccine mandates. One of those applies to employers of 100 or more, and the other one applies to government contractors. And again, there was guidance that just came out on that at the end of last week. So you can check my website for additional details on those two things if either of those apply to you. And the CDLE just reminded Colorado employers of 16 or more individuals that they must continue to provide the 80 hours of pandemic leave at least until November 15, 2021, because a federal state of emergency remains in effect. And that is true, even though on September 30, the federal tax credit expired to allow companies to pass that through. So Colorado employers have to continue to provide that 80 hours of pandemic leave through at least November 15, 2021. It could be extended, even though as of September 30, 2021, they were no longer able to pass that through in the form of a federal tax credit. That's certainly something I have seen being misreported in some local newsletters, even lawyer newsletters, and have gotten calls from peers and colleagues at other law firms to confirm that is the case, that this pandemic leave does stay in effect. It's certainly a big area of confusion right now. So check my website. There's some additional details on there, including some emails that I copy pasted in from the CDLE that explain that. All right, just a little quick about me, and then we're going to get into the materials. I do labor and employment law, and I work with companies on a fixed fee recurring monthly basis. So if a company wants to work with me, it's the same fee every month, whether I work a lot or a little, and work out with them, how much that would be and how much time they think they might need. Fees can be from small to large. It depends on how much time is generally going to be needed, and it's a neat way to practice and to partner with companies. If that sounds like it might be of interest to you, I do labor and employment law. Feel free to give me a call. We'll grab a coffee and go through what it is that I do. You can see on my website the services I offer for more detail. I've been doing this since 1991 and practicing law since 1988. I'm a frequent author and speaker. In fact, you probably, good chances you may have heard my voice before, including, for example, on 850 KOA. I was just supposed to be on this morning and I couldn't make it. So I also I published a column in the Denver Business Journal for, I think it was about 15 years. So, all right, that's me. And again, there's my website, l2slegal.com. One quick note on, now we're getting into the substance. What are we not going to talk about? We're not going to talk about one of the most important HR things you should be thinking about as a startup. And that's because it's not really something I do or that labor and employment lawyers do. There are plenty of labor and employment lawyers who do this, but they generally will do it in the form of like another kind of company. Maybe they set up that's not a law firm, and they provide this service. It's a service that one does not have to be a lawyer to do, and that is to be an HR professional or an HR consultant. In fact, it's really a different discipline to be the HR professional or HR consultant. I would say it's a lot like being a police officer versus a district attorney. So I am not an HR professional and I'm not an HR consultant, but I have been an employment lawyer and a labor lawyer for 30 years. What specifically that means is I do not provide consulting services for things like DEI, diversity, equity, and inclusion. I wanted to highlight that because it's critical. It's very important. And so even though it's not part of the domain of an employment lawyer per se, it is certainly something where an employment lawyer has some good thoughts about probably. But there are really experts in this area who provide that service, and I'm not one of them. So I wanted to highlight for you that even though it's not something we're going to talk about today, if you're thinking about employment things that your startup may need, I would probably start with DEI. I would reach out to a DEI consultant. If you need help finding a DEI consultant, I am happy to help you refer to someone. I just Thursday attended a presentation by a local attorney who also provides DEI consulting services. Her name is Ruchi, R-U-C-H-I, Kapoor, K-A-P-O-O-R. I thought she gave an excellent presentation. I can refer you to her, happy to do so. She talked about a lot of really great specific ideas of how to set up a workplace so that there are good DEI values built right into the structures of your workplace. Again, that's not an employment lawyer thing, that's more of a consultant thing to help you figure out. She talked about org charts and workforces workflows and flat workforces and triangular work groups. And these were really great ideas. I thought that she had very great recommendations, and happy to refer you to her. You can also find some other great DEI consultants in Denver, so feel free to reach out. But I definitely think that is a place to start. And I just wanted to highlight it because it's not part of my materials, only because it's not what I do. And I'm going to talk about employment law, straight technical nuts and bolts legal issues. But DEI also is helpful in that regard. It does help to mitigate against legal exposures of all kinds. All right, so let's get into our first legal issue. Pop quiz. Does your company use independent contractors? Yes or no? I'm not going to do a poll because I'm not quite sure if the answers get tracked and preserved, and I think probably nobody wants that tracked. But Does your company regularly use independent contractors? Or do you anticipate that it will? If so, this first topic is critically important. It is not uncommon for startups or even established companies to come up with a great idea for doing business, but think that they're going to bypass these employment-related taxes and requirements, legal issues, by classifying workers as independent contractors. In fact, it's so common, I would say there's, depending on what industry you're in, it may even be part of the industry norm to call people independent contractor. And I do see some people coming in on the chat that yes, and one person saying we did and had a past labor audit. So we're going to talk about that. Yes, so it's a real risk. Good feedback from people on that. Let me just give that a quick skim. Yeah, so some people, oh, and apologies for being a little late on the start. There was an error on the link that I got to start. So if you were waiting on hold, that's why. All right. You want to be very careful about using independent contractors. Strict federal, state, and local laws apply, and they restrict the use of independent contractors. These requirements are different depending on where you're doing business and what kind of business you're doing, what agencies you're involved with. So it's just too complicated of a topic to really dig into all the nuts and bolts today, but we're going to go through some of the highlights. The federal government's requirements are becoming stricter under the current administration of President Biden. And you've no doubt heard about the efforts to crack down on a number of companies, including very well-known gig economy companies. And you should realize that Colorado is actually among the strictest of the states on its requirements for independent contractors. So very, very careful here if you're going to use independent contractors. In short, if your startup's business model is to try to earn a profit by avoiding these expenses of employment laws and employment taxes, you should contact legal counsel immediately before you start using independent contractors. You should figure that out before you start using independent contractors, not after. Why? Because some of this liability survives even a bankruptcy of an entity and can attach to individuals. So that means you could start your business, rack up big liability, file for bankruptcy, and that liability could follow you personally. So you've really got to think this through before you start. Once you start, it can also be very difficult to change because of the tax treatments. So make sure you're figuring that out. What about the economy, the big so-called gig economy companies? We all know who they are that are doing this. Well, you're hearing them getting cracked down on by courts, government agencies, all over the country. You see in California, the gig economy law that was passed just on this issue. And for the average startup, that kind of lobbying effort, that kind of legal fee is probably not something that you could sustain. And look what's happening to even the big companies who have massive budgets. They're facing potentially fatal challenges. These are real serious exposures. So number one issue, I would say, make sure you talk before you start using independent contractors about it with an attorney. All right, another pop quiz. Is it sufficient if your company and the contractor agree that they are an independent contractor? You guys agree to it. And they tell you they want to be it. They're the ones who ask to be the independent contractor. And they even tell you they won't work as an employee. They'll only work as an independent contractor. You put all of that into writing, and they're working under their own business EIN. And one of the people noted here, they're only using individuals with LLCs. So that's an example of that. They're working as an entity. They've set up an actual legal entity, and you're paying that legal entity's EIN, not the individual social security number. And you get a Form W-9 from that entity. And you don't watch them work, and you don't make them fill out a timesheet. Is all of that enough? No, it is not. And yes, someone pointed out already, they've jumped in, great answer. No, it is not enough. Well, all of that is recommended, and some of it is effectively required, we're going to see. But even all of that together is not sufficient to make someone an independent contractor. If you're looking to use independent contractors as part of your business model, you face serious hurdles. And again, those are federal and state government agency, different tests, courts have different tests, all different tests. So you have to think through them all, and the strictest tests apply for their purposes. Can your company get sued, audited, etc., by the government, even if it was the contractor's idea? Maybe it was the contractor who came to you and said, I want to work as a contractor. I won't even work as an employee. They put it in writing. Can you still get sued or audited for that? Answer, not yet. The answer is yes, for sure. Not only can the contractor sue you who wanted to work as a contractor, but other contractors can sue you. They can assert a class or a collective action. Even former contractors could be part of that. Your company could face a class or collective action of a broad number of people over years. Under state law, it could be even 5 years, and under federal law, 3 years. So potentially some serious scope here. Workers cannot waive these rights. And a lot of the issues I'm going to talk about today are laws that workers cannot waive their rights on. So even if it's their idea, they can't waive that right. It's just built into the law. It says they can't waive this right. All right, so what is required? Let's just look at one summary. Remember, there's a lot of different summaries, a lot of different laws that apply. Let's look at one. That's the Colorado Department of Labor and Employment's. And I'm going to take a drink of water and give you a chance to look at that paragraph right here. Here's their introduction, and I'll give you a second to, and then I'm going to summarize it. All right, there's a couple of important things here. Number one, has to be shown, unless and until it is shown. By whom? By you. Okay, the burden is on you to establish as a company independent contractor status. It is not on the individual to establish they were an employee. You have to prove they're an independent contractor. What do you have to prove? Number one, they are free from control and direction in the performance of services. Okay, that's probably the factor everybody knows and has heard and just assumes is, from what I see, even lawyers, I hear lawyers telling me that's the only test. It is not the only test. It has never been the only test. The next is the individual is customarily engaged, like their regular job is, at this, whatever they do. And that is, and whatever they do is an independent trade, occupation, profession, or business. Independent. We're going to come back to independent. Remember that. That's one of the real problems. All right, continuing with the CDLE's summary. The CDLE notes that should be in a written contract under Colorado law, and if it's not, you don't get the advantage of certain things in Colorado law, so it really should be in writing. And there should be certain disclaimers set forth in there, and those disclaimers need to be in bold or a large face type or underline, and the contract should confirm the relevant facts that establish the person is an independent contractor. So it's a fairly technical contract. I mean, it takes me hours to review one of these for a client at least, and to talk to the client and get the facts and think it through and make sure it really fits. This is not something where one size fits all, and the quality of the paper, we would say as a lawyer, the drafting really matters, but even more so, the facts of the circumstances really matter. So it takes time for me to understand with clients how they're actually, what they're actually doing and how they're doing it. All right, what are the factors that we should be thinking about in the contract that must be confirmed? CDLE summarizes them here, and these are just some of the factors really, but these are the ones that come out of these particular Colorado laws. The person is not required to work exclusively for your company. although they can work exclusively for your company for a limited period of time if they want, but they are not required to, so you can't have a non-compete kind of thing. Company does not establish a quality standard for the individual. You're not telling them what the plan, you can provide them plans and specifications regarding the work, but you can't oversee the work or instruct them on how to do the work. And the company does not pay a salary or hourly rate, but rather a fixed or contract rate. That's a very frequently negative factor for companies that want to use contractors, is they're often not paying this fixed or contract rate. They're paying a salary or hourly rate, and that is not consistent with being a contractor. Company cannot terminate the work during the contract period unless the individual violates the terms of the contract or fails to produce the required results. So they can't be like terminable at will, for example. The company does not provide anything more than minimal training. So they got to come to you capable of doing whatever this business is. The company doesn't provide tools or benefits. You're not buying them a computer or health insurance. And you don't dictate the time or performance. You're not, and this is a problem because if they're later determined to be an employee, you haven't kept time on them. So it could be real double whammy to get hit with this kind of a claim. You could owe them the difference for having not paid them as an employee, plus all the overtime and minimum wage and all that stuff. It can be very expensive. And you can't pay them personally, rather make checks payable to their trade or business name. So that's just one factor. So again, paying an LLC is an important factor. That's a really good thing, but it's only one thing, and it is not sufficient to establish an independent contractor relationship. It's only one of the many factors. All right, back to this idea of what an independent trade is. Colorado has a case that came out in 2019 that gives us kind of a sense of this. In 2019, this case came out, and this company, Colorado Custom Made, they had an arrangement with a variety of cleaners who they would refer to homeowners who wish to have their home cleaned. And then they would pay those cleaners, they would collect the money from the homeowners, and they paid the cleaners a contractor rate, not an employee rate. They didn't pay the employee taxes and so forth. They didn't pay unemployment, they didn't pay workers' comp. Supreme Court held that the cleaners were employees. The cleaners were doing and they were working independently of the Colorado Custom Made organization. The Colorado Custom Made organization, according to the court, did not come in and check the quality of the work, et cetera, et cetera. They just were working as this referral agency, is what their position was. The Supreme Court held no, those employees were still employees of Colorado Custom Made. They were the ones that were doing the very cleaning that Colorado Custom Made was contracting to have done with the homeowners. They were doing it when and how Colorado Custom Made had contracted with the homeowners. And that was true, even though those cleaners were providing cleaning services to companies other than Colorado Custom Made. Although it is true that maintaining outside clients supports a finding that individuals are engaged in an independent trade, the Supreme Court said, this factor is not dispositive, but it's just one of many to be considered. So again, each of those factors is just one factor. Satisfying any one of those factors is not sufficient. The Supreme Court said this fact pattern was that ruling then was summarized by the CDLE, Colorado Division of Labor and Employment, later as follows. The Supreme Court noted this fact pattern was far from a situation where Colorado Custom Made was a mere referral company that obtained a referral fee for connecting the cleaners with the clients. It billed the clients, it paid the cleaners, ensured the work was done, and that work was the very work the cleaners were doing. In other words, the cleaners were doing the work CCM was in the business of providing to clients. So CCM was contracting out the very kind of work that it contracted to do. It was contracting out its business. That's what the Supreme Court said. And that's how the CDLE summarized it. That gives you a sense that in Colorado, this idea of independent, and really, I don't think this is going to be very different in most states. If you you should not expect it to be super different in most states. Let's put it that way if the issue comes up there. You can expect that the courts in Colorado are going to follow that decision. It was a Supreme Court of Colorado case, and that the CDLE, the Colorado Department of Labor and Employment, is going to follow it. They've told you. They told us all right there. That's how they summarize the law. All right, again, tip, how do you mitigate against this risk? If your company is thinking you're going to use independent contractors, especially related to do the kind of work that your company does, your company's business. You're a computer software developing company and you're going to use contractors to write that software. Maybe in the context of your company's circumstances, for whatever reason, that might be okay, but both those authorities right there suggest it is not going to be a clear answer. So make sure you're contacting and consulting with a lawyer about that before you do it. Again, once you've done it, it can be very hard to put this spilled milk back in the bottle. Now compare that to a hypothetical where that maid service were to hire a painting company to come in and paint its offices. Sure, I mean, painting an office space is not what that maid service apparently was in the business of doing, and that might be okay. But if they're doing the actual work, if it's integral to your company's business, real risk there. And federal law is not very different under the Trump administration, and that's not a pejorative to use just the president's last name, by the way. That's just how I was always, I understand you refer to the administration. So under the President Trump's administration, they did take a more friendly approach to companies wanting to use contractors, even published some proposed rules. Those rules were in part struck down by a court in New York and then immediately frozen in their entirety by the Biden administration, President Biden's administration. So the Biden administration, the federal government is going to be taking a very strict approach, which you should expect or can expect. All right, again, consult with legal counsel before you do this, especially if the contract is going to be integral to your business. Reconsider using independent contractors if they're integral to your business. In other words, doing the kind of work that your company does. Reconsider using them if you exercise control, provide tools, monitor their work, pay them an hourly rate, all those things we talked about. Reconsider, do enter into written contracts to memorialize independent contractor relationships and have those reviewed by legal counsel. Again, they're not one size fits all. And be sure your contracts comply with federal and state law as where applicable. And that it can include in some localities like cities, some cities do have requirements for these things. Again, the liability can be substantial and individual. Government agencies like the IRS, DOL, CDLE, plaintiffs' attorneys and their plaintiffs and their attorneys can and often do pursue these claims. They are being filed every single day all over the country. And they include class and collective action exposure. They include exposure for taxes, penalties, liquidated damages, interest, as well as attorney fees. And that those claims can sometimes even survive bankruptcy, depending on what kind of claim they are, and can even have individual liability attachments, depending on where they are and what kind of claim they are. This kind of claim can be so severe, it can put even some of the largest businesses out of business. If you start out, though, with appropriate relationships and avoid this, it's usually a matter of the economics of how you structure the relationship in terms of wage rates and so forth. So figuring it out on the front end is super important and feasible. Figuring it out on the back end can be very difficult and sometimes just isn't possible. It can end a company and result in individual liability for the founders, managers, etc. All right, let me check if there's any questions on that. All right, I am not seeing any questions. I'm in the chat. Again, if you do have questions, feel free to type them right into the chat, in Zoom. All right, let's get back to it then. Again, pop quiz. If the work you need can be done by a qualified person from their home on their computer when they want at their time in the way they want, and if they insist on being paid a salary and you agree to pay them a salary, can you agree to do that? Can you just go ahead and pay them a salary and not have to keep track of their time and not pay them any overtime? We got one correct answer already. The answer is no. Oh, two correct answers. All right, awesome. No and no, correct. That is not enough. The person has to qualify for an overtime exemption. They cannot be treated as exempt, even if that's what they want, if they are not actually qualifying for an overtime exemption. Just paying a salary is not enough. Overtime pay and minimum wage laws are required for all employees unless they meet an exemption. I'm sorry, overtime and minimum wage are required for all employees unless they meet an exemption. Federal and state laws both specify strict requirements to meet the exemption. You can check out the federal website there at the link I gave you for some overview of information about what the federal exemptions are. And there's a website link to the state that you can check out for some additional information on Colorado exemptions. And note that Colorado law, any state law, locality, whatever law, can be more restrictive than the federal or vice versa, whichever is the stricter law controls for that law's purpose. So you have to comply with all of the applicable laws. Can I post these links in the chat? You know what, if you want to get the links for the person who asked, I want to keep going. So what I would ask you to do is just shoot me an email at the end of the presentation at your convenience, and I will respond with the slides, and then you'll have the chat, and then you'll have the links. The stricter, let's see. Yep, simply paying a salary is not enough. And then I added in here too, there are special rules for tipped employees. If your business is going to have tipped employees, you'll want to check out the rules for them as well. There are too many exemptions to cover in this presentation. They're actually not only the main ones that many people know about, but there are some really specific ones that have been lobbied for over the years. Like there's one there's an at-home basket weaving exemption. Isn't that crazy? Holiday baskets or something, or wreaths, I think it actually is. So there are many exemptions, but there are basically a handful that are the most important and most common, the ones that come up most often. And in those, there's pinch points that I think are the most common. I don't know. So let me just talk about those real briefly for you. Executive employees, they must be guaranteed a minimum salary, and they must meet a duties test. Oh, I think I missed one thing here. On the state law, oh, it will be coming up to it, but if I forgot to have it in a slide, be sure to check the state law for the applicable minimum salary for these positions, because it is going up in Colorado, and it's different than the federal one. So you want to make sure you comply with that. All right, the executive must not only get the salary that's a minimum guaranteed salary, it must meet a duties test that includes managing an enterprise, the entire enterprise, or a department or subdivision of the enterprise, and must supervise 2 or more full-time equivalent positions. An administrative employee must be guaranteed a minimum salary, the minimum salary that's specified, and have discretion and independent judgment over matters of significance. And that does not simply mean making important decisions or needing to know how to do the job well. They actually have to have independent discretion and judgment over matters of significance, not simply how to run the business on a daily basis. That's a higher burden than I think many people think. Professional employees are what the laws refer to as learned professionals. As an attorney, I'm a learned professional. A doctor is a learned professional. There aren't a lot of the learned professions as specified by this law. That is not a derogatory comment about other kinds of industry, other kinds of positions, and saying they're not professional. They're certainly professional in every other sense, but the law here is talking only about, the law is written by Congress, is talking only about people like me or doctors. Even in the medical world, highly skilled technicians like ultrasound technicians are generally not considered to be learned professionals. Okay, so that's not my phrase, that's the statutory phrase. There's also another exception specifically for computer professionals. They have their own hybrid pay requirements, but they have to be responsible for systems analysis, systems development, or design. They can't simply be what computer people call bug busters, the people who help you set up your computer, fix the problems, get your printer working again, those kinds of things. That's not what the law is referring to as a computer professional. The cat just woke up, so if you heard that, that was the cat. All right. What if you give the worker ownership or equity? No, the government knows about that, and the courts know about that. That alone is not enough to turn the person, convert them out of employee status and to allow them not to be paid overtime or minimum wage. There is a business owner limited type of exemption. The site here is here in the slides, but they have to basically own 20% equity in the business, and they have to be actively engaged in management, just as two thresholds. There are additional requirements. Those requirements add up to meaning they have to own at least 20%, and they can't just be working a lot every day to get it. They have to be making high-level owner-type decisions, really deciding how to run the company, where the orientation of the company is. Very high level. So if you're thinking that an owner constitutes or is not due overtime or minimum wage just because they have an ownership interest, you definitely want to talk to a lawyer about that and make sure that they qualify for this or some other exemption. A note on equity benefits. Oh, here we go. If you want to pay someone, ask the question, if you want to pay someone a salary, can you ask them to work 70 hours a week some weeks and not have them get overtime, or would they need an exemption for this? They definitely need an exemption. Just getting salary is not enough. They may have to also get the minimum salary as defined by the higher of federal or state law, but they will also have to get, that's a minimum thing that they have to get the salary. Then they have to fall into one of those exemptions, or else it doesn't matter. You've paid them a salary and you owe them overtime, which gets even more complicated. And again, employees cannot waive these rights. So even if it's the employee who wants to get paid the salary, they cannot waive this. All right, if you're thinking of offering any kind of equity on the topic of equity, just want to point out equity and equity type benefits are very complex. They are something you'd want to talk to your tax counsel or tax professional about, and also an ERISA attorney usually. There are different kinds, ERISA qualifying and ERISA non-qualifying, different kinds of treatments for both, and which kind of equity you give can really make a difference for the growth of your company. So you probably also want to talk to an attorney who is skilled and experienced in the area of whatever it is you're hoping to see happen to your company. So if you're hoping to start it up and get acquired, you probably want to talk to an attorney who does mergers and acquisitions and find out what kind of equity is the right kind of equity to offer. Because if you offer the wrong kind, it can make your company toxic or at least difficult to sell. Same thing for investments, all kinds of things. So make sure you're understanding what the right kind of equity is for your company. Don't just use documents from somebody else's company, and realize that's a sophisticated level of analysis that issues. All right, again, if you think any of your company's employees qualify for an exemption, even an owner, okay, even an owner, even a boss, even a person who does the really important whatever it is for your company, you need to talk to a lawyer because these exemptions are technical and they either fit the exemption or they don't. They can't ask their way out of being treated as a non-exempt employee. So just because they ask to be treated as exempt, hey, it's your obligation to make sure you treat them the right way. Do this before you start your business, because again, these are issues that can create exposures that, depending on where you are and what kind of claims you face, can even survive bankruptcy or attach to you or other managers individually. Again, these rights cannot be waived by the individuals, even at their own request. Two things that also, like equity, deserve a special note: deferred comp and flex time. Deferred comp and flex time are often inappropriately used by startups and other companies as if they were alternatives to these requirements. We're going to give you deferred comp. We're going to give you flex time, and you can just take off next week if you work a little extra this week. That is not how it works. There are specific rules on that. Deferred comp is not simply saying, hey, we'll pay you some or all of your paycheck or your time that you are legally entitled to later. Okay, that's not deferred comp. Deferred compensation is a specific kind of legal benefit. It's basically the deferred part of deferred comp isn't we're going to pay you later. It's we're going to pay you in such a way and at such a time that the taxable event may not occur. At this time, it may occur at a different time. So it's a tax issue thing. You want to get a sense of exactly what it is that you're trying to accomplish with deferred comp and talk to a tax professional about it. One of the more common kinds of deferred comp is a 401k. So deferred comp is not simply saying, hey, I'll make it up to you in a week and put it into your next paycheck. Strict rules do apply, though, on things like 401ks and other forms of deferred comp. You need to consider talking with a tax professional and a risk attorney about setting up those plans. Comp time is generally only allowed within a work week for private employers. So for private companies, that means non-government companies, you cannot say, if you want to take off an hour early today in this week, just work an extra hour next week. No, you can do that within a work week, take off today and work extra tomorrow, all within the same week, because time is kept on a weekly basis. But if you're doing something that affects next week's time, that's not permitted for private employers. That is permitted for government employers, some government employers, not all government employers. So companies have seen that. Some company founders may have seen that at government places and think, oh, I can do that. No, there's only certain government employers can do that. Private employers generally cannot do that. Here's the SHRM site with additional information on that, and you can see SHRM says no, that's not allowed. The DO describes that as not being permitted, although it's a acceptable practice in the public sector, it is not permitted in the private sector. And that, by the way, is true even though everybody wants it. Every employee and every employer, I can remember for 30 years has wanted this. And every single time, I mean, it's like almost every year candidates run on the idea they're going to change this, and then they get into office and they never do. So comp time outside of the work week is not permitted for private employers. All right, another pop quiz. Can you let your workers decide when to take breaks and meal periods? Can you even let them, for example, push all of their breaks and their meal periods to the end of their shift so they can leave early? Hey, you know, I got 2 10-minute rest periods and my 30-minute lunch today. How about I push those all to the end of the day and I leave, you know, an hour early, 50 minutes early? Can you do that? Or I push them to the front and I'll come in 50 minutes late. Can you do that? The answer in Colorado is no. Unless employees qualify for an Yeah, unless they qualify for an exemption, and there are certain exemptions just for these issues too. There are strict federal, state, and sometimes local requirements for meal periods and rest breaks. Yeah, somebody commented out, I thought so until I saw it to the end of the day. And even in the middle of the day, we'll see there's some connection, some restraints there. All right, meals and rest periods. There are specific requirements at the federal and especially at the state level. In Colorado, you can go to the link here in the slide and see the state's summary of meals and rest periods. Meal periods are required in Colorado for at least 30 minutes during any shift exceeding of 5 hours or more, equal to or greater than 5 hours. And those meal periods must be taken at least 1 hour after the start of the shift and 1 hour before the end of the shift. Meals can be unpaid so long as they are uninterrupted and the employee is completely relieved of duty. And that means they're not working and you don't walk up and talk to them. If you walk up and talk to them, then you got to pay them for that meal period. And you got to pay them for the time that they work. So it can get very expensive. So you've got to make sure that when employees are in meal periods, they're not being interrupted. So that's why companies have meal rooms, break rooms, things like that, and you don't go bother them. You got to untrain your supervisors train your supervisors, rather managers, to not walk in and say, hey, can you get me the such and such file, or what's the deal with such and such? No, you got to leave them alone for that 30 minutes. 10-minute breaks need to be provided in the middle of each 4-hour work period, and that turns into this math on this chart that you can see here for the number of rest periods, depending on how long the shift is. And here too, meals and rest periods cannot be waived. They're probably some of the most common wage hour claims right now in lawsuits that are being filed all over the country. And they also result in all those things we talked about, potential liability that survives bankruptcy, individual liability penalties, liquidated damages, attorney fees, etc. So be very careful about meal and rest period compliance. All right. Second here, let me check where we're at with the chat room. Additional requirements for should rest periods be paid by the employer? Yes. Generally, yeah. And you can check that and find out to confirm. It depends on who your employees are and what the requirements are and whether they're exempt, etc. New hires, I-9s, etc. Remember that when, oh, let me see, wait a minute. I got a question here that's pretty long. Person is saying they hire a lot of seasonal employees and want to be paid a manager. I'm not quite sure I really fully understand that question, but looking at it, I do think that's a very specific question that I can't answer as part of a webinar. That is the kind of thing that you would need to talk to someone and get legal advice for. You know, it's like if you talk to a doctor, doctors can't give medical advice in the form of an educational program like this. So, all right. New hires, you do need to complete I-9s for all new hires within the first 3 working days. And if you are working remotely, like many of us are, because of the coronavirus, et cetera, there are some special rules on that. You can hop on the government's website there and see. So they have been somewhat relaxed. They have not been relieved. It's just the way that you observe and verify the documents is a little bit loose, but you still have to do it. Remember that new hires also have to be reported to the new hires must be reported to the state's new hire directory within 20 days. And let's see a question. Referrals for attorneys. Well, I mean, I'm happy to talk to you if you want to give me a call after the presentation. There are many attorneys you could find that represent companies on these issues too. All right, new hires must be reported to the state's new hire director within 20 days. There's the link to that information for that website. If you're required to run E-Verify, or if you're running E-Verify because of the nature of your business, not every company does, so you have to figure that out. If you are, you can only use it under strict rules, and E-Verify misuse is certainly an issue. It's an issue, it's such an issue that both the Colorado Secretary of State's website and the federal website have information on the most common violations. So let's give that a quick review. And if you are using E-Verify, make sure you're not doing any of these common violations. E-Verify can only be used after an individual, this is the state's list, can only be used after an individual accepts an offer of employment and completes Form I-9. Must be used within 3 business days of the new hire's actual start date. Cannot be used to verify eligibility status of existing employees. Other than doing it for new hires in that window, you can't just go do it for a current employee. And it must be used to verify the work status of all such new hires. If an employer elects to use it, you can't just do it on certain employees. You can't select just, I'm going to run it on Joey. Here's the federal government's list. You cannot immediately terminate employees because they receive a tentative non-confirmation. You have to go through the process. Creating duplicate cases for the same employees is often a violation. Requiring an employee to use self-check. You can go through this list yourself if you're using E-Verify. And check that website. They explain this in further detail. All right, on hiring, another common thing for startups is in our area, our location, our footprint in the Colorado Front Range, is certainly high-tech hires. And many high-tech hires are coming in potentially on an H-1B visa. It's not uncommon for companies that are looking for high-tech talent to be looking for such talent both in the state, in the country, and outside the country. And to the extent they're coming in from outside the country, they'd be coming in on, it's not uncommon, an H-1B visa. If you have such a need, you can consult with Immigration Counsel. I don't do that. Happy to refer you to some, but there are multiple in the Denver area who are great. But definitely make sure you're finding out what those rules are. And I'm going to check the chat. All right. And again, if you do have questions, feel free to lodge them in the chat and I'll keep answering them as we go. And we're doing good on time too. In posters, you have federal and state posters. Most companies solve this by purchasing posters from a poster company, but you can verify that the posters that you've acquired are the correct ones. Here are the links for the federal posters and for state posters. And there are additional such links in all other locations. Check your local cities, check any other states where you work. This is a good list to get you started. For additional information about federal employment laws, you can also go to these websites here. I gave you the SHRM website with a bunch of additional tools and resources that they make available. And Colorado, for example, has quite a few resources at the CDLE, again, Colorado Department of Labor and Employment's website. One quick note is that in Colorado, we do have a law called CADA, C-A-D-A, and that's the Colorado Anti-Discrimination Act. That is Colorado's state law version of the federal EEO laws like Title VII, the ADA, et cetera, et cetera. The CADA applies to employers of all sizes, whereas the federal laws often have a size limit, like you have to be 15 employees or more for a certain law to apply. So realize that if you're in Colorado or other states, you've got a law, check to make sure you know your laws that you have applicable to your company. And in Colorado, for example, you'll have one CADA that applies to employers of all size. Question here is about how are companies getting, I'm guessing that's companies getting around that, I think, posting requirements with remote employees. You can't post the posters. Remote employees and posters are a very specific topic you want to think through with your HR professional or employment lawyer. That's one thing where I definitely would need to know more about why that person is remote and what we mean by remote. It's very different if they're working at home remotely and that's their job versus when they have a cold, they go home and work at home. So we do need to think through that. And even people working at home during this time period of coronavirus, for example, there's real issues and exposures that you need to talk to a lawyer about or need to at least think through in terms of the safety of the workplace. Isn't that interesting? People can be injured in their own home and file a workers' comp claim, and it is happening during this time period. And even OSHA citations sometimes for home work. There are real specific rules around all of that. So we need to have good ideas. Same thing for posters. Oftentimes during this period, many companies are doing posters and just distributing them by email, but it really is very specific to each company and what we mean by remote work to answer that question, what is required. All right, pop quiz. Is it a good idea to save some money and use another company's employment documents, offer letters, handbooks, policies, etc.? No, it is not. No, do not. The laws that apply to companies do vary by size, number of employees, state, location, type of business. So the documents that worked for one company may not have any relevance to your company. In fact, you may be taking on obligations that they had that you don't have. You may be promising to do things you don't have to do. And there are even some things that would be illegal for you to promise to do. They're great. They're awesome things to do, but they're not legal for your company because you're not subject to the law that requires and authorizes them. So you cannot just blindly use another company's documents. And again, get that figured out first, because once you start, it can be very hard to unwind this. Be sure that your documents do confirm that unless you believe otherwise, all employment is at will. And that means anybody can quit or be discharged at any time with or without notice, with or without cause. Good place to confirm that is in an offer letter, if you do offer letters. It can also be in a policy. It can be done verbally. It can be done in a handbook. You may do it everywhere. And in Colorado, it is presumed that all employment is at will, but it isn't necessary. There are many exceptions and a lot of lawsuits filed over it. So make sure that that is clear if that is what your company's intent is. Offer letters can also, if you choose to use them, confirm start date, starting rate of pay, pay days, job title, any benefits, etc. And be sure that you have your offer letters and all your employment documents reviewed by counsel or an HR professional, or that you spend real time thinking through it if you think you're competent to do so, because you want to make sure that they, again, are compliant with the laws that apply to your company, but also that they're not inconsistent with each other. That's a very common thing that we see in lawsuits is the offer letter says one thing, the handbook says another. This policy over here says a different thing, and then the benefits document says a completely different thing. So you really want all of these documents to work together as a portfolio. Here's a list of some common policies that are in handbooks. And again, I am not a DEI professional, but certainly as an employment lawyer, I draft and review and revise employment policies all the time. And some of that involves some of these issues. And so, be sophisticated how you approach this as you're writing policies. Think about pronouns. Think about he, she, they, how you write that. Use inclusive language. Think about having good EEO policies. Think about having good EEO complaint procedures. Be sure, by the way, that your policies are specifying the correct protected classes under Colorado and federal and local laws. For example, in Colorado, we now have some protections with regard to hair under the Crown Act. So you really got to have your protected classes reviewed and updated, and make sure they are consistent with the law. You'll also be looking at code of conduct, code of ethics. If you're publicly traded, you've got certainly a lot of obligations there. Conflicts if you're looking for capital investments, purchasing, things like that, you want those to be pretty sophisticated. That's something that a buyer or an investor is going to be very interested in. Your business expense reimbursement policies, meals and rest periods, we talked about that already. Bring your own device to work policies, that's what they're actually called, BYODs, isn't that funny? And posting restrictions, sick leave, family, medical leave, those are very complicated. We'll talk about those a little bit. Holidays, vacation, paid time off. So those are some of the common policies. They're not the only policies, but they're pretty common. Vacation, sick leave, and PTO. Federal and state law have very strict requirements with regard to these. They have strict requirements with regard to COVID-19 related leave. They have strict requirements with regard to general sick leave. In Colorado, we now have. We're about to have a state administered program. In addition, you've got to make sure that you're thinking through and developing appropriate policies that take into account these other requirements. For example, it is not enough to offer more in PTO than all those laws add up to. Let's say you offer 200 hours of PTO and you said, hey, people can take it for any or no reason. I've offered 200 hours. That's more than everything else combined. You may still, if you haven't written that policy right, be obligated to provide the 80 hours plus the 48 hours plus the new state administered program that's coming up. So really very complicated topic. Make sure you're getting that, doing that research yourself or retaining a consultant or an employment lawyer, preferably an employment lawyer, because these are technical legal issues to look at. Special note on vacation in Colorado, under a brand new case that just came out in Colorado, employers are required to pay out vacation on separation. They cannot condition that on, for example, giving notice of resignation. If you don't give me notice of resignation, I'm not going to pay you your vacation. No, you have to pay the vacation. In a recent town hall meeting, the Colorado Department of Labor and Employment announced that it was considering defining the word vacation to include, we don't know what. And they didn't say, they wouldn't say. When asked, the CDLE's answer was, I don't know, things like schmaycation. That was the word that he used, the CDLE person I was listening at. I've never heard schmaycation. He said, just calling it schmaycation doesn't make it not vacation. I thought, he's thinking of PTO. Well, sure enough, last week, the CDLE issued proposed rules you can find on their website that will clarify, in their mind, in a lot of people's minds, change the law to say PTO is going to be treated as vacation and will have to be paid out. Those proposed rules say sick leave can be treated differently. Does an unlimited PTO policy solve these problems? Unlimited PTO policies are extremely, I believe, risky for these employment solutions. I think you absolutely need to talk to an employment lawyer before you use one. The problem with unlimited PTO is, number one, it's not unlimited. In reality, we all know kind of how much time we can take off. So that's a problem in these cases. People are challenging them because they say, it wasn't unlimited. You really only let so-and-so take off so much and blah, 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 blah. Additionally, we all kind of know what we're supposed to be taking off. So if you don't pay it to me, you owe it to me. And people do file claims and say, look, everybody knows you get a week off and I get my week, I didn't use it. Additionally, PTO policies and vacation policies do not undermine the exemptions for exempt employees because there are specific requirements that the DOL has said are met by traditional vacation and PTO policies. The DOL has not ever been asked to opine, and no court has ever been asked in a case yet to decide whether or not, that I know of, maybe there are some that I just don't know, but I track this stuff, so I'd be surprised if anybody does know, please tell me. But I haven't seen it yet come up. I think it's absolutely going to come up, whether or not unlimited PTO is compliant with those technical requirements. If it's not, you lose the exemption and you have an even bigger problem. Unlimited PTO is also extremely unpopular, studies show. So if you want to find out about unlimited PTO, using it, I would definitely talk to an HR consultant, because HR professionals will tell you many companies start this, try this, and it just is so unpopular, they reverse course. You can see some of the biggest companies in the country have done that. And I would definitely recommend you talk to an employment lawyer, because it is a very untried solution. In my mind, it's a lot of risk to throw into something. So I do not recommend unlimited PTO in general, and would not say no. I would definitely not say it's a clear workaround for these issues. All right, let's get back to vacation PTO, regular PTO now. You connect up those dots. You're talking major exposure, right? All of your employees are entitled to all of their unused vacation or PTO. You give them 3 weeks a year and they only take one, and they work for you for 30 years, that's 60 weeks. You're talking real money here. So when companies have not structured their PTO programs appropriately, for example, with an appropriate, well-drafted, no additional accrual policy that says you only accrue up to this level, you never accrue beyond it. You've written that correctly. There are rules. Companies haven't done that. It can make your company toxic. And I made a note here. Even if your company is spinning off great EBITDA, or EBITDA, however you want to pronounce it, EBITDA, you're very profitable. If you've racked up this kind of potential liability, I have seen purchasers walk away from deals. I have seen investors walk away from deals. I have been the employment lawyer on cases like that, trying to help purchasers and investors figure out what that potential liability is. I've seen that affect the purchase price. I've seen them knock down the purchase price, the amount they're going to invest, and whatever. The economics can be affected too. There can be a price point adjustment. So this is really, really big exposure here. Get those reviewed by counsel first. Get this figured out first. Write it up correctly, and it will cost you less, and you'll have less risk. Check the chat here. All right. Let's take a quick water. Oh my goodness, my glass dripped. All right. Non-disclosure agreements, non-competes, non-solicits, non-work for hire, work for hire agreements. Federal and state laws strictly define what can be included in any of these agreements, and the requirements vary significantly, not only by location, but on the circumstances of your company's business. This, again, is another topic outside the scope of this presentation, but it's worth touching base on for startups. Make sure you're figuring out your non-disclosure agreements, your non-competes, your non-solicits, and your work for hire agreements. Consult with employment counsel about drafting these appropriately to meet local and state law and federal law. And now there's special language under federal law that you want to see in there. So, really put the time into developing appropriate forms for your company. Do not simply use the forms from another company. Again, these rules are different. The way these rules apply is also different depending on the company's circumstances, its location, the state where it is, even locality, like a city sometimes. So make sure you are getting appropriate documents, and realize that if you are using another company's, or you're using bad documents, you can actually increase your risk of legal exposure. Check out, for example, recent ruling just this week with regard to former President Trump And Omarosa, we all know from television, where she won an award from an arbitrator and attorney fees because the NDA was held unenforceable. So these can be very important that your documents are being reviewed and prepared appropriately. Having said that, do not fail to take advantage of these very important and valuable tools to the extent they are available to your business. If these are important for your business to protect your trade secrets, you really want to be thinking about using good documents. Check the chat. Workplace fraud. Prevent workplace fraud as well as unlawful discrimination, harassment, and retaliation. One great way, just one step towards doing that, in addition to having proper policies, good DEI, is to consider having an anonymous complaint reporting procedure. If your business has things that can be stolen or misappropriated or even misused, you might want to check out this report by the Association of Certified Fraud Examiners. They publish it, I think it's like every other year or something like that. And it has a kind of a unusual name, and at least to me, it's a little unusual. It's called the Report to the Nations, plural, nations. But it is a great document. There's the link to it. And it gives you a real sense of what workplace fraud is and how it's prevented and who commits it, and what common kinds of frauds are. Very educational. For example, under the ACFE's most recent statistics, they confirm that 43% of workplace fraud is discovered as a result of a tip. So an anonymous tip hotline, very important tool. Also a great way to help prevent discrimination, harassment, and retaliation. You give people the ability to file a complaint. Another interesting statistic from that report while we're on the topic, who are the most common fraudsters? What are the most damaging fraudsters? Who are the most damaging fraudsters? Well, it may not be what you think. Employees commit 41% of known fraud cases, but only for a median loss of $60,000. Managers commit 35% of the known fraud cases for a whopping $150,000 median loss. But owners and executives who commit only 20% of known fraud cause, on average, a median loss of $600,000. So very interesting report, help give you a sense of kind of what and how to protect your company's assets. Remember, taxes, workers' compensation, unemployment, new hire reporting, W-2s, W-4s, 1099s, all of that's got to get done. You've got to set up unemployment insurance, workers' compensation, pay your federal and state employment taxes quarterly, all that stuff, new hire reporting, tax forms, all that, etc. Get with your accountant, make sure you're setting up your taxing and your government portals and so forth. Some areas that you can consider for some additional help as we close out our presentation. Consider consulting, and if you have any questions, now's the time to type them in before we close. Consider consulting with your insurance professional about possible coverage, such as employment practices liability insurance, key person insurance, disability insurance, directors and officers insurance. Oh, I wrote offers. That's funny. Officers, it should be. Some additional topics here. We're not going to get into, I just put them on one slide to just mention. There are rules for hiring. Make sure you're aware of what those are on promotions and hiring and postings related to them. Now that in Colorado, it's gotten to be a lot more complicated. Make sure that you are complying with interviewing rules like ban the box laws, pay history bans, criminal history checks, background report requirements. All of that, there's a lot of specific rules around. Colorado now has a social media law. You cannot just tell your employees to give you their social media account or to make it available to you or to do things for your business on their social media account. There's rules around all of that now too. And remember that although it's not an employment law issue, privacy and data privacy requirements are increasingly important that you get a good sense of what you're doing, especially if you're collecting social security numbers, medical information, home addresses, et cetera, which all companies eventually do. So you got to really make sure you're figuring out your data privacy issues and requirements and know how you're going to do that, and that you're prepared in the event of a data breach. Record keeping. Once you've determined the employment laws that apply to your business, develop a record keeping practice, and those requirements do vary substantially. So consider consulting with an employment lawyer to make sure you're understanding what your record keeping requirements are for all these different laws, what you need to keep, how you need to keep it, where you need to keep it, what you need to keep it away from, who needs to have access to it, who can't have access to it, how long you need to keep it. Some options to help you achieve compliance on these issues. You can look for employment law firms, especially ones that, like mine, work on a recurring fixed monthly fee, so that you know you're not going to get a higher fee in any given month. If you use me a lot, next month you get the same fee bill. If you don't use me the month after that, you get the same bill. It's a level billing system. Look for firms like that, or look for firms that are doing other alternative fees, maybe a minimum and a maximum, or a collar, it's called sometimes. Consider engaging an HR professional, especially to help you get started. Remember, HR professionals do not have to be employment lawyers. Many are, and they have professional experience, often SHRM certified, other great organizations certified, and they're able to help give you some real sense of how to spin up your business and get started. Staffing agencies and professional employment organizations may also be helpful. All right, are there any questions? And I will check now to see if there are. I'm not seeing any. We're about 5 minutes before the end, so I will give us a few minutes. Again, if you have any questions, go ahead and type them into the chat function. You're welcome. Thank you. You're welcome as well. Thank you. Ah, thank you. What a great comment. This has been fantastic. Thank you. While you guys are typing in any final questions, remember you can go to my blog on www.l2s, like lead to succeed, L, the letter L, like LMNOP, the number 2, the letter S, like Stephen, legal, www.l2slegal.com, and sign up for my blog. It's free, and you know, I update with cases and statutes and everything else as it comes out that I find interesting. What is the fair monthly fee for the employment law company? I think that question is asking me what would I charge. It depends on what your company needs. So feel free to give me a call. Look on my website. Again, it's www.l2slegal.com, and you'll see the kinds of services I provide. I always say to companies, if you need at least 2 or more of those a year, then you probably, you might have a benefit from a relationship with an employment lawyer like me. And it's just a matter of figuring out what the right fee is for what your actual use is. And we'll talk about how many hours you might need, what you might need, what kind of services you might need. Like I say, I've been doing this for 30 years. It might sound complicated, but I have a pretty good sense of what that is. I also track my hours. I disclose those to my clients. And then my clients are able to see if they're getting the bang for the buck that they were hoping, and or if they're getting too much service and not enough fee. And I've had clients call me up and say, hey, we want to increase your fee because we love the service. So it's available information for clients. And so if you're interested, feel free to reach out to me and to answer that question. All right, anything else? I think we're getting close. All right, well, for the moderators, we are just 3 minutes in advance. So I will go ahead and let you know. I will stay on the line until 4:30, but I will consider this presentation done. I sure enjoyed it. And thank you all for your great feedback as we put this on together. Again, apologies for the delay in getting started. I had just been sent the wrong link, so I couldn't get in. All right. Well, I will stay on the line in case there are any more questions. Otherwise, I think we're finished. And if there's a moderator who picks up, feel free to jump in. You're welcome. Thank you all.